Lordship, can we commence, Lordship?
Yes, please. Yes, please.
Yes, Lordship. Thank you, Lordship.
Yes, Prof.
Thank you.
Yes,
Thank you so much, Your Lordship. Yes. A very warm welcome to all the dignitaries, faculties, advocates, professionals, and students. I'm Hepzibah, and I'm the MC for today. And I welcome you to the International Conference on Arbitration Post-2020, organized by Chennai Dr. Ambedkar Government Law College, Pudupakkam, in association with the Directorate of Legal Studies, Government of Tamil Nadu. Before we commence the inauguration ceremony, I request you all to rise up for the Tamil Thai Vazhai.
நீராறும் கடலுடுத்த நிலமடந்தை கெழிலொழுகும் சீராறும் மதனமென நிகழ்வரத கண்டனில் எக்கணமும் அதில் சிறந்த திராவிடனில் திருநாடும் தக்க சிறு நிறை முதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறம்பியந்து செய்ய மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
Thank you. You may be seated now. Now it gives me great pleasure introducing our beloved principal, Professor Dr. Gowri Ramesh, who has boldly taken steps to make the lockdown period vibrant for both the faculty and the students by organizing various webinars on different topics of law. This international conference is special in every way, and we are happy that our Honorable Lordship has agreed to grace this occasion. I request our dear principal to welcome everyone gathered here in the virtual mode. Over to you, ma'am.
Thank you, Hepsi. Respected dignitaries, panelists, principals, faculties, academicians, students, and members of the legal fraternity from various parts of the globe, I extend my warm welcome to one and all present here to this first international virtual conference on arbitration organized by Chennai Dr. Ambedkar Government Law College, Pudupakkam, in association with the Directorate of Legal Studies. I deem it a great privilege to welcome Honorable Justice Thiru Sundar, Judge, High Court of Madras, and I thank His Lordship immensely for accepting our invitation as a panelist to discuss on arbitration post-2020 amidst his busy schedule. I would personally like to thank him for his words of encouragement to me and when I approached his Lordship for this event. Thank you, Your Lordship. I also extend my warm welcome to Honorable Justice G. Jayachandran, who is also a part of the dignitaries attending this event. Thank you, Your Lordship, for gracing this occasion. I wholeheartedly welcome respected Thiru Gopi Ravikumar, Law Secretary, Government of Tamil Nadu, and I extend my heartfelt thanks to Sir for accepting to inaugurate today's conference and to deliver the inaugural address amidst the challenging work that is being handled by him during this pandemic situation and the unwavering support we have always received from him till date. Thank you, sir. I take this opportunity to thank our respected Director of Legal Studies, Professor Dr. N.S. Santhosh Kumar, sir, without whom we would have not been able to take this giant leap of organizing an international event within a short span of conducting a first national webinar. We thank you, sir, for your constant encouragement and inspiring mentorship. At this moment, I take pride in informing the audience here that our Chennai Dr. Ambedkar Government Law College, Pudupakkam, is the first college among the entire government law colleges in Tamil Nadu we organized the first national webinar on June 5th on environmental law. And here we are at the end of the same month organizing the first international conference too. We have proved that it is not the size of the team that matters to win, but the effort and hard work of the dedicated faculty, which has now placed our institution in the international arena. We will be coming up with many more national and international webinars in the days to come under the able guidance of our Director of Legal Studies. I am in awe of the collective expertise gathered here from UK, US, Lebanon, and India as panelists for today. I welcome Professor Dr. Yusuf Farah, Dr. Natalie Najjar, Professor Dr. Samia Tabusum, Mr. Inba Vijayan Veeraraghavan, and Mr. Anirudh Krishnan. We are deeply honored to welcome you all. As the convener of the event, it is my duty to introduce the topic to the audience gathered in this virtual conference. When we read the history and background of the evolution of the concept of arbitration, we are taken back to 990 BC, the reign of King Solomon. The case of the twice claimed baby was handled wisely, and an unconventional strategy was used to solve a dispute between two mothers. Both the women brought their disputes before King Solomon. The fact that they appeared before a judge of their choice made him an arbitrator. The wise king, in his legendary wisdom, pronounced an award to split the baby between the two mothers, and in an unconventional way tested the veracity of the claims. The reason I narrated the story now is to highlight the fact that the topics to be dealt by the panelists today is in one way or the other about the arbitrator's role or the arbitral award. The concept of splitting the baby does not refer to splitting the relief, but it may be considered for dispositive motions or for bifurcating the arbitration proceedings. Therefore, that there has been a false belief that arbitrators split the baby and deliver awards that represent a compromise between the claimants and the respondents in arbitration. This is one such example of a misconception, and to dispel all such myths in the minds of the participants, I request the speakers to throw more light on the topics and the participants to engage by raising their queries towards a healthy discussion. We will be discussing on different aspects that need to be addressed as we move on to the next decade. We have eminent guests and experts to discuss on a post-2020 arbitration scenario. And therefore, I conclude by thanking my organizing team, Mrs. Devi, Mrs. Rekha, Mrs. Hepsiba Beulah, Mr. Shyam Sundar, Mrs. Madhumita, and Mrs. Kritika, and all my other faculty members who have made sincere efforts to enhance the quality of the conference. I once again welcome you all and thank you. Thank you, Hepsi.
Thank you so much, ma'am. Yes, we have distinguished guests from around the globe and we will have interactive sessions with them. Our respected Director of Legal Studies, Professor Dr. N.S. Santhosh Kumar, is unable to join the session due to a technical snag. He will be truly missing the session as much as we miss his keynote address. Our chief guest today is Thiru Gopi Ravikumar, Secretary to Government Law Department. Due to certain unavoidable circumstances during this pandemic situation, our respected chief guest has handed over a recorded version of his inaugural address. He has been our constant motivation in conducting the online webinars, and Chennai Dr. Ambedkar Government Law College, Pudupakkam is indebted to Sir for being a part of this international conference by sending us the video. I request the host to play the video recording now. Over to you, ma'am.
Honorable Mr. Justice M. Sundar, Judge, High Court of Madras, Professor Dr. N.S. Santhosh Kumar, Director of Legal Studies, Professor Dr. Gowri Ramesh, Principal, Chennai Dr. Ambedkar, Government Law College, Pudupakkam, delegates from United Kingdom, United States of America and Paris, principals of all other government law colleges in India, in Tamil Nadu, faculties, students, good afternoon to one and all. Happy to meet you all virtually in this webinar event. I am honored for being given this opportunity to inaugurate this international virtual conference on arbitration post-2020. Chennai Dr. Ambedkar Government Law College, Pudupakkam deserves a special appreciation for organizing this international virtual conference in this pandemic situation. I am informed that this college has organized 3 webinars during the current month of June. The first one on 5th of June on the World Environment Day, the second one on 20th June in commemoration of the International Refugee Day. Recently, on intellectual property rights issues and challenges was organized. I congratulate the principal for her stewardship and the support rendered by the assistant professors under the able guidance of Professor Santhosh Kumar. The topic for this webinar is Arbitration Post-2020, an important and relevant area of study in the present scenario. In this era of globalization, the boundaries of nations have almost become redundant. Free trade and commerce across the world is becoming the order of the day. In view of the manifold increase in trade and commerce, commercial disputes are naturally bound to increase. It is known fact that the regular courts in a country are overburdened with the pendency of cases. Alternate dispute resolution such as arbitration, mediation and conciliation will play a substantial role in relieving the courts of that burden. Statutory backing for arbitration and conciliation in India was given in the year 1996 on the enactment of the Arbitration and Conciliation Act 1996. This act is based on the model law on international commerce arbitration as adopted in 1985 by the United Nations Commission on International Trade Law. This act applies to both international as well as domestic arbitration. In the year 2015, amendments were made to the Arbitration and Conciliation Act for settlement of disputes in a more user-friendly, cost-effective and expeditious disposal of cases, and to facilitate and support international arbitration. A noteworthy feature of this Amendment Act is that an Indian court can exercise jurisdiction to grant interim measures even where the seat of the arbitration is outside India. Thereafter, in the year 2019, the Arbitration Act was again amended based on the recommendation of a high-level committee under the chairmanship of Justice B.N. Sri Krishna, former judge of Supreme Court of India. The 2019 Amendment Act introduced arbitral institutions to be designated by the Supreme Court or High Court. These arbitral institutions would appoint arbitrators. Further, an independent body, namely the Arbitration Council of India, was brought in for the purpose of grading the arbitral institutions and accreditation of arbitrators, etc. India is no doubt on the track to establish confidence in its legal system, which is the fundamental requirement for any country to become an international arbitration venue. I appreciate the principal and the faculties for their efforts in creating such a new platform for the students to learn and gain knowledge from renowned international panelists. I sincerely hope that the webinars organized by Chennai Dr. Ambedkar Government Law College, Pudupakkam, will motivate the other government law colleges in the state to follow suit. This would certainly pave the way for the development of legal education in Tamil Nadu. With these few words, I take great pleasure in inaugurating today's international webinar on arbitration post-2020. Nandri Vanakkam.
We thank respected sir for taking time amidst his busy schedule and delivering the inaugural address. Now we move on to the main part of the event. We will be having 6 sessions being moderated by our faculty. I will be introducing the moderators as we proceed with each sessions. Now I request other participants other than the speakers and principals and faculties to switch off your video to avoid any technical snag. Now I request Mrs. V. Rekha, Assistant Professor, Chennai Dr. Ambedkar Government Law College, Pudupakkam, to moderate the first session.
Thank you, Hepsi ma'am. Now I am pleased to introduce our guest panelist, Honorable Justice Thiru M. Sundar, Judge, Madras High Court. Honorable Justice Thiru M. Sundar was born in Chennai. His Lordship graduated from the Madras Law College in the first batch of 5 years integrated law degree course. His Lordship enrolled as an advocate in 1989 and practiced primarily in the Madras High Court. His Lordship had a wide spectrum of practice on the civil side, especially in arbitration cases. His Lordship was a standing counsel for TWAD Board and Government of Tamil Nadu between 2003 and 2006. His Lordship was sworn in as a permanent judge of Madras High Court on 5th October 2016. His Lordship was chaired with the then Honorable Chief Justice of Madras High Court, Justice Indira Banerjee, in various sensational cases like MLA's disqualification case, Arvind milk adulteration case, and so on. With this brief introductory note, may I now request our Lordship to deliver his address on the topic, Challenge of an Arbitral Award under Section 34 of the Arbitration and Conciliation Act 1996. Lordship, the forum is yours.
Thank you, Professor Dr. Rekha, for the introduction. Being the first speaker, I'll just start with the formal address. Professor Dr. Gowri Ramesh, Principal, all the professors and all those who form part of her team, good afternoon. Co-panelists, Professor Dr. Yusuf, Dr. Najar, Professor Dr. Samia Tabasum, Mr. Inba Vijayan, and Mr. Anirudh Krishnan. A very good early morning, a very good morning, and good afternoon. In that order, to Professor Tabasum, Dr. Yusuf, and Dr. Najar, and all others from other parts of the globe who have joined us. More importantly, greetings to my fellow students of law. When I say fellow students of law, there are two reasons for that. One, they are students of my alma mater, and they will also be alumnus and alumni of this institution in the years to come. The second reason is, I strongly believe I've not stopped learning, and therefore I said fellow students of law, greetings. Before I even plunge into the topic, I will have to congratulate the organizers for the effort that has been put in. I'm told this is the inaugural and first international virtual conference. I'm also told there were 4 earlier virtual national conferences. This is a very good academic exercise. I'm very happy for my alma mater, and I need to congratulate Principal and the entire team who are working on this. And I'm also given to understand that all this is being done without collaborating with any other entity. As it was mentioned, Mr. C. Gopi Ravikumar, Law Secretary, and Professor Dr. N.S. Santhosh Kumar, Director of Legal Studies, I'm told, are giving adequate support and encouragement to the team. Therefore, I need to place on record my congratulations and best wishes to them also. Please do convey it to the Law Secretary and your Director, Professor Principal, and the other professors. Now, with regard to the topic, the theme is Arbitration Post-2020. Therefore, it's futuristic. And the sub-theme which I have chosen to speak on is challenge to an arbitral award under Section 34 of the Arbitration and Conciliation Act 1996. When I make an attempt to share with you what my thoughts are on challenge to an arbitral award under Section 34 of the Arbitration and Conciliation Act, I would request all the participants to keep 4 principles, legal principles or concepts in mind. Quickly, they are like this. An arbitral tribunal is a private tribunal chosen voluntarily by the parties by exercising party autonomy. It is voluntary and it is a creature of the contract. It is not a creature of the statute. As Professor Dr. Gowri was mentioning, Solomon, the oldest and the earliest known arbitrator, was chosen by the parties. Therefore, an arbitral tribunal is a private tribunal chosen by the parties, and it is a creature of the contract, and it is voluntary. 1. 2 is more in the nature of a sequitur to 1 or a corollary to 1, and 2 is an element of finality is attached to the award or the verdict returned by this arbitral tribunal. 3 is a further corollary to 2. That is, element of finality would not mean complete elimination of judicial review. There would be very, very limited judicial review in tune with minimum judicial intervention under specific slots. And that is Section 34. Therefore, the third principle is delicate balance between sanctity of the finality of arbitral award and the sacrosanct philosophy attached to judicial review in legal parlance. It's a delicate balance between the two, and that is Section 34. And lastly, the fourth principle I would request all the participants to bear in mind is when we talk about Section 34 and challenge to arbitral award under Section 34, we are talking about domestic awards and not foreign awards, being foreign awards within the meaning of Section 44. Talking of foreign awards, let's have clarity. We are not talking about international commercial arbitration within the meaning of Section 21F. Foreign-seated arbitration results in a foreign award. Section 44 is what you would look at. And with regard to the second principle, Section 35 is the section in which finality of the arbitral award principle is ingrained. Before we move on further, we'll just hold on the PPT, please. Whoever is putting the PPT on screen,
Yes,
just hold on with the PowerPoint.
Yes,
I think Professor Rekha is assisting me, or
Kritika will be
Kritika
the
is-
host, Lordship.
I'm the host, sir. Kritika. Yes, sir.
yes, please. I don't see Kritika on the screen. What I would request you is
Yes, sir.
get the PPT on when I make a request.
Okay.
Yes, Lordship.
Sure,
The
sir.
slides, not now. I propose to do that while I conclude.
Okay, fine, sir.
I
Sure.
propose to conclude with the PPT.
Okay, sir. Sure.
Now, talking of the Arbitration and Conciliation Act, very quickly, that is dated 16/8/1996, and it came into force on and with effect from 20th August 1996, and it has undergone 2 major amendments, both of which impact Section 34. One amendment is Act 3 that came into force with retrospective effect from 23/10/2015, and the second one is Act 33 of 2019. Mind you, Act 33 contains of 16 sections, and 11 out of these 16 sections alone have been notified on 30th August 2019, and that impacts Section 34. The second amending act, namely Act 33 of 2019, consists of 16 sections and it is dated 9th August 2019, but it did not come into force on 9th August. 11 out of these 16 sections came into force on and from 30th August. One of them impacts Section 34. This is broadly the statute which we are looking at. Let's have clarity on the statute which we are looking at. It is with that purpose that I mentioned about the statute and the two major amendments the statute has undergone over its 2 decades of existence. Now, as far as Section 34 and the challenge to an arbitral award is concerned, primarily, what is it? Is it an appeal? No. Is it a revision? No. Is it a review? Not a full-fledged judicial review. Therefore, I would say no, not a review. Then one may ask me, what is this challenge to an arbitral award under Section 34? What at all is that? It's not an appeal. It's not a review, not a revision. It is a mere challenge to an arbitral award under 8 specific slots adumbrated in Section 34. As simple as this. These 8 slots, drawing inspiration from the expression used by Supreme Court, I have written pigeonholes. I call them pigeonholes. 8 pigeonholes. When you challenge an arbitral award, all required is a party assailing an award should be able to demonstrate to the court that the challenge fits into one of these pigeonholes. If it does, the award is dislodged, any one or more. If it doesn't, the award is sustained. This is the basic scope of Section 34. Section 34 consists of 6 subsections, all of which are one way or the other relevant, but the most relevant one is subsection 2. The 8 slots are the 8 pigeonholes which I referred to, under which an arbitral award can be assailed or adumbrated in subsection 2. Let's have a broad look at what these 8 pigeonholes are, and thereafter what I propose to do is, when I take you through the PPT, I intend giving you a panoramic view of all these 6 subsections. Now, as far as the 8 pigeonholes are concerned, 5 are under 34(2)(a), 2 are under 34(2)(b), and 34(2)(A) is one slot by itself. 5 plus 2 plus 1, 8. 5 under 34(2)(a), 2 under 34(2)(b), and 1 a slot by itself, 34(2)(A). Now, as far as 34(2)(a) is concerned, a party approaching the court should be able to establish on the basis of the records of the arbitral tribunal. Earlier, it was the party furnishing proof. That is up to 29th August 2019. On and from 30th August 2019, party furnishing proof, that expression has been replaced by establishing on the basis of records of the arbitral tribunal. Now, with reply, I would just quickly take you through that when we go through that. These 5 grounds are basically incapacity of a party, invalidity of an arbitration agreement, no notice to regarding the appointment of the arbitrator, or procedurally party not being given adequate notice, and then what I call wandering. When I say wandering, when the arbitral tribunal has either discussed or decided on issues or disputes which have not been submitted to the arbitral tribunal for adjudication. And lastly, the fifth one is when the constitution of the arbitral tribunal is not in accordance either with the arbitration agreement or not in accordance with the statute. These five fall in one basket. The other two, 34(2)(b) are, one is when a non-arbitrable dispute has been decided by the arbitral tribunal, when it is not arbitrable under the law of the country concerned. And two is public policy. This has been a major area and it may call for a separate lecture by itself. These two, non-arbitrable dispute being decided by the arbitral tribunal and public policy, fall in one basket. Under 34(2)(b), it is not party establishing from the records of the arbitral tribunal. The language used is court finds. If the court finds, unlike 34(2)(a), 34(2)(a) 5 pigeonholes, you should be able to establish from the records of the arbitral tribunal. 34(2)(b), where the court finds. That's the most important distinction between basket 1 and basket 2. The third one is a basket by itself, 2A, patent illegality. Patent illegality is a ground by itself. Now, with regard to patent illegality, it was brought in by the 2310-2015 amendment, though earlier it was added to a ground of challenge by a judgment, namely saw pipes. We'll not go into all that. That may become that may become a bit of a digression. I don't want to go into that. I'm also keeping an eye on the clock because I'm conscious of the spread of this seminar. Therefore, it will suffice to say that as far as these two grounds are concerned, the court finds. Now, public policy pigeonhole ground and patent illegality are further circumscribed. Therefore, I have written these pigeonholes become pinholes. The reason is, in public policy, the explanation to public policy says that does not entail a review on the merits of the dispute. Very important. One of the reasons why I say it's not an appeal, not a revision. And with regard to patent illegality, there are 2 points which circumscribe. One point is mere erroneous application of law cannot be a ground to successfully assail an arbitral award on the ground of patent illegality. Therefore, mere erroneous application of law is excluded. And 2, that is excluded very interestingly, is reappreciation of evidence. Reappreciation of evidence is excluded. Therefore, public policy and this patent illegality are further narrowed down. This is broadly the 8 grounds on which, or 8 slots under which an arbitral tribunal can either be dislodged or set aside, if one may use that phraseology. Before I quickly take you through the PPT and conclude, when I go through the PPT, you will see the case laws. I put in the case laws in the PPT. It's there, the citations are there, and the bullet points are there. What I see is, from 20th of August 1996, when the present Act came into force, the Act which is now in vogue, the Act which is operating, to date, I would refer to till about 2-3 months ago, when the last of a lead judgment on jurisdiction was rendered by the Honorable Supreme Court. In this, roughly over 2 decades, 2.5 decades, the case laws would bring to light 10 principles have emerged. I'm just giving it in a nutshell to make it as simple as possible. I'll just run through the principles. I'm not going to elaborate on that. I'm not going to elucidate on that. Quickly, I will run through. One, it is jurisdiction. Jurisdiction under section 34 is now essentially decided based on the seat of arbitration. This is my understanding of the obtaining position of law. Two is with regard to subsection 5. Subsection 5 talks about a pre-application notice, like a pre-suit notice. Before a party to an arbitral award challenges the award, decides to challenge an award, that party should put the adversary on notice, saying that I intend assailing the award under 34. This is subsection 5. Now that has been held to be directory and not mandatory. Therefore, subsection 5 is directory and not mandatory. But principle number 3, the entire section 34 and these 8 slots, an application under section 34 is a summary procedure. Please bear in mind, it is a summary procedure. Principle number 4, subsection 6, an application under section 34 should be disposed of within 1 year. 1 year from the date of receipt of the subsection 5 notice by the noticee. Now that subsection 5 has been held to be directory and not mandatory, this 1 year reckoning date will be the date of presentation of the application. That is the view that I have taken, that appears to be holding the field. And 6 is amendment. There are 2 amendments, I said, one on 23/10/2015 and the other on 30th August 2019. Now, these amendments impact section 34 as I mentioned earlier. When a section 34 is heard out, the amended 34 will be applied irrespective of when the arbitral proceedings commenced and when the arbitral award was rendered. That is the obtaining position of law, as far as that is as late as Hindustan Construction, Sanyong, and then of course Kochi, and then section 87 was struck down. I'll just quickly take you through the PPT, but the point is the amended section 34 will be applied even if it is a pre-amendment arbitration or a pre-amendment award. And then 7 is requisition of arbitral records from the arbitral tribunal for the 5 grounds, and 8, no review on merits. 9, when an award is set aside, suppose a 34 is filed and the applicant is successful, the prayer of the applicant is acceded to, the award is set aside. The question is, can there be a re-arbitration? The answer is yes. That is one aspect. And lastly, this arbitral tribunal, as all of you are aware, is to be constituted by an odd number, not by an even number. Section 10, subsection 1. 1, 3, 5, 7, and so on and so forth. In the light of Sanyong, prior to Sanyong is the latest case law. When an arbitral tribunal is put to challenge before a court, let's assume it's an arbitral award, not the arbitral tribunal, sorry. Arbitral tribunal also can be put to challenge, that's a different provision altogether. When an arbitral award is challenged, let's assume that award, the impugned award, was made by a 3-member arbitral tribunal. And let's assume that it's made by a 2:1 majority. Then, before the court, there is an award and that award is tested. This is how traditionally 34 was applied. Now in Sanyong, what has happened is Supreme Court has upheld the minority view, set aside the award and said the minority single arbitrator who took the minority view is correct. That is what has happened in Sanyong. That is the 10th principle which I'm able to deduce from the vast case laws between 1996 and to date. Now I'll quickly take you through the PPTs, 18 slides. It won't take, I'm sure I won't take more than 15 seconds slide, and therefore I'll quickly finish it in 10 minutes. Can we have the slides, please?
Yes, Your Lordship.
Kritika, right?
Yes, yes, Your Lordship. Yes, Your
Who's
Lordship. It is now done.
You're a
Lordship.
student or you're Professor Kritika?
He's an assistant professor.
I am a
one of the
faculty
faculty.
working here, sir.
Yes, Professor. Yes, Professor Kritika.
Yes, Your Lordship. It has been displayed now.
Yes, please. One by one. Section 34. This is the opening slide. We'll go to number 2, please. The negotiating history, I already mentioned. The 1990s Act is based on the uncitral model and when it came into force. Most important facet of the sublime legal philosophy, I even call it sublime legal philosophy and salutary principle, underlying the 1996 Act is minimum judicial intervention. That is because voluntarily chosen private tribunal made by contracting parties being the creator of the contract. Next slide, please. Section 34.
Yes,
Now,
Your
I
Lordship.
already mentioned to you that Section 34 is not an appeal, is not a review, and the time available for a party, this is under subsection 3, to approach the court under Section 34 is 3 months. Thereafter, a further 30 days is provided. It's not 120 days, it's 3 months and 30 days. What is significant is, even a day's delay beyond this 3 months and 30 days cannot be condoned. The lead case law is simplex infrastructure. You will see that as we go to the further slides. And this subsection 5 I already mentioned has already been held to be directory. 2015 amendment, how it has impacted section 34. Public policy has been statutorily explained. You will see explanations 1 and 2. I'm not going to read that. Subsection 5, which prescribes for pre-application notice, held to be directory now, and subsection 6, which prescribes a 1-year time frame, were also brought in. Public policy statutorily explained is one of the main amendments brought in. The other amendment is subsection 2, capital A, where patent illegality was made one of the grounds of attack. 2019 amendment, the only impact as far as section 34 is concerned is furnishes proof that under 34(2)A was replaced with establishes on the basis of the records of the arbitral tribunal. I already mentioned that. We'll go to the next slide, please.
Yes, Your Lordship.
Simplex infrastructure. This is the citation. 3 months and 30 days is non-negotiable. The cap is sealed. The next one, please. Next one, please. FISA developers. FISA developers and MK Global, 2017 SEC 796 and 2018 9 SEC 49. These two case laws lay down that section 34 is a summary procedure. Therefore, please bear in mind that when you invoke section 34, it is a summary procedure and 1 year is the time frame under subsection 6. Next slide, please. Public policy. As I mentioned, this is the main area where several awards are assailed. Now you will see I have given 5 case laws. In this slide alone, I have given the case laws with the dates, but that is with a specific purpose. The purpose is, you will see there is a space between 4 case laws on the top and 2 case laws at the bottom. The 4 case laws on the top are prior to 23/10/2015, meaning prior to the term public policy being statutorily explained, vide explanation 1 to section 34 2B2. 2 at the bottom, Centrotrade and Sangyong, are post 23/10/2015. The reason why I'm spending a minute on this is sometimes a doubt arises as to whether judgments rendered prior to 23/10/2015, particularly Associate Builders and Western GECO, which lay down 3 juristic principles for public policy. If I go into that, that will consume a lot of time, can be applied to a post-23/10/2015 scenario because public policy is now statutorily explained. The answer is in the affirmative. It's yes. Central Trade reiterates Western GECO 3 principles, and Sangyong makes it clear that the Associate Builders principles have to be read in the context of 23/10/2015 amendment. Therefore, the simple point is, when you are dealing with public policy and a challenge to an arbitral award on the ground of public policy, the principles laid down, the juristic doctrines laid down in Western GECO and Associate Builders, though prior to 23/10/2015, can be applied post 23/10/2015. Supreme Court has said so in Sangyong. That position is very clear. Very quickly, the 3 doctrines, I would take only a minute on that. The 3 doctrines are very, very simple. Judicial approach, natural justice principles, irrationality/perversity. Not only the 3 doctrines, specific tests for these 3 doctrines have also been laid down by the Supreme Court. For judicial approach, the test is fidelity of judicial approach. And then for NJP, natural justice principles, the test is time-honored odi altrum partem. And the last one, irrationality/perversity, the test is the well-known Wednesbury principle of reasonableness. This much about it. It is still applicable irrespective of 23/10/2015, prior or later. We'll go to the next slide, please. Next slide, please. Yes. This Bhumi Vikas Bank is the judgment where Supreme Court held this pre-application notice under subsection 5. That's a party intending to approach the court, putting the other on notice, is merely directory and not mandatory. That is the Bhumi Vikas Bank is an authority for the broad principle that subsection 5 is directory and not mandatory. But there is an observation in Bhumi Vikas Bank in paragraph 26 where the Supreme Court says all courts dealing with section 34 shall make every endeavor to adhere to the 1-year timeline. Now that subsection 5 has become directory, it will be 1 year from the date of presentation. We'll go to the next slide, please. Next one, please.
Yes, Your Lordship.
Arbitrability of disputes. Now, one of the grounds is 34(2)(b)(1). A dispute which is not arbitrable being decided can be a ground to set aside an award. One may ask, what are the disputes which are not arbitrable? The lead case is Booz Allen, and after Booz Allen, the series of cases you will see Vimal Kishore, Ayasami, Himangani, Lifestyle, and Vidya Drolia. Now, 1 to 4 and 6 are Supreme Court judgments. 5 is a division bench judgment of the Madras High Court. Division bench, but I had the privilege of penning that judgment for the division bench. So Lifestyle captures Booz Allen and Ayasami and gives the list of non-arbitrable disputes. And Vidya Drolia, subject to correction, yet to be delivered. The reason is, in Himangani, the question as to whether arbitration clause in a lease deed is valid was the question. There were 2 schools of thought. If it is not with regard to recovery of possession, it is valid. And then if it is only with regard to recovery of rents, it is valid. And then doubting the correctness of Himangani in Vidya Drolia, the matter was referred to a larger bench. I'm informed that the larger bench of the Honorable Supreme Court has heard it on 4th of February 2020, and the decision is awaited. Vidya Drolia is a judgment in which, doubting the correctness of Himangani, there was a reference to a larger bench. Lifestyle is where I had written challenge to patent not arbitrable, infringement of patent, arbitrable. That much about the arbitrability of disputes. The next slide will give you a quick list. Can we go to the next slide, please?
Yes, Your Lordship.
The 6 disputes held to be not arbitrable in Booz Allen. Disputes relating to rights and liabilities which give rise or arise out of criminal offences. Matrimonial disputes relating to divorce, judicial separation, restitution of conjugal rights, child custody, guardianship matters, insolvency and winding up, testamentary matters, eviction or tenancy matters governed by special statutes. And Vimal Kishore added one more to this: trust deed. There can't be an arbitration clause in a trust deed. Any number of reasons are there. I'm just giving you the list. And then, of course, whether there can be an arbitration clause in a lease deed is now the Supreme Court's decision on the matter. We'll go to the next one, please. Next slide, please. Yes. This is on jurisdiction. This is very, very important. I'll just spend 1 minute on that. The long and short of it is, now, as you would see, you would find hardy exploration is one where Roger was not considered and therefore BG is held. I don't want to take you through all that because it's going to take a lot of time. In very, very simple terms, the position which can be culled out, obtaining position is jurisdiction, quae section 34 will be determined by the seat. All of us know seat determines the curial law. Then you have the governing law, which is the governing law for the arbitration. Curial law is law applicable to the arbitral proceedings. Governing law is the law applicable to the arbitration agreement. And 3 is proper law for the contract. Now, what is important is you will see the Act does not talk about seat. The term seat is not mentioned in this Act. It talks only about place. Seat, curial law are all part of march of law. Now, in this post-2020 scenario, now when we may have very many arbitrations on video conferencing platforms where geographical location pales into insignificance, what is important is, it is very important that the seat, venue, and therefore curial law, governing law, and proper law for the contract are set out with clarity and specificity by the parties. This would eliminate a lot of grounds under section 34. This much about it. And the next one is amendments, how to be applied. I've already mentioned. So BCCI turned on section 26 of the first amending act, and then Sangyong and Hindustan have now clarified that the amended section 34 will apply irrespective of whether the arbitration proceedings and award was pre-23/10/2015 or post-23/10/2015. That will suffice, because if I go into it, this will consume a lot of time. And this is issues in BCCI, section 26 of the first amending act, and what the Supreme Court has held. And the BCCI has, then we'll go to the next slide, please. And then Sangyong is one where section 87, which took away the substratum of BCCI ratio, was struck down. So therefore, post Sangyong, amended 34 will apply irrespective of whether it is post or pre 23/10/2015. And lastly, you have the Hindustan construction. All these fall in one category. And Sangyong, I've already mentioned, for the first time, minority view in a 2:1 award made by a 3-member arbitral tribunal was held to be correct. The award was set aside and the minority view was held to be the correct view. Any number of reasons given. It's a very, very scholarly judgment. I think all of you can take time off and read through the judgment. And I think we have now come to the very last slide. The very last slide. And that's the conclusion. I would conclude with this: salutary principles and sublime philosophy underlining section 34 are inter alia constituted by, this is my view, A, delicate oblique fine balance between sanctity or finality of awards and sacrosanct need for judicial review. Talk of sanctity or sacrosanct need, we are talking in constitutional parlance. Can we have the last slide, please? And
Yes, Your Lordship.
Section 34 has very limited contours, and the perimeter of Section 34 is made of these 8 slots, and a court dealing with 34 would perambulate within this perimeter. And lastly, C is expeditious disposal, which in any case is one of the pillars of ADR, alternate dispute resolution as a mechanism. This is all that I had to share with you on 34. I had tried to encapsulate, I had tried to give it in a nutshell. In the process, I had run through like knife and butter on few of the subjects which might have, few of the areas which might require little more attention. So with this, I conclude and hand the floor back to Professor Kritika or Professor Rekha, whoever is.
Yes,
Back to
thank
you,
you,
please.
Lordship.
Back to you.
Thank you, Lordship. Indeed, it was like a mother feeding her child. Lordship had fed us with plenty of information. Thank you so much, Lordship, for the insightful speech and taking up this session to the next level. With the permission of Lordship, I am moving on to the questions for the session. Though we have received a lot of questions, I am restricting myself with the 2 questions.
Yes.
The first question is, Lordship, under what circumstances does a court have discretion to extend the time limit for enforcing an arbitral award? Okay, Lordship.
Enforcing an arbitral award, that is under 36. We are on 34.
Yes, sir. Yes, Lordship.
Ideally, that would take us into a long drawn lecture. So
Yes.
therefore, I would, very difficult to, yes.
Yes, Lordship. Next question.
34, I would take it up, please. 34, I take it up, please.
I don't find
The
the
idea is I can relate to what I've said and quickly give an answer rather than embarking on another mini lecture by itself. That's the whole idea.
And then what are the rights available to the non-signatory third parties to an arbitration agreement, Lordship?
Under 34?
Yes, Lordship.
There is a provision. You can seek leave of the court. You can seek leave of the court if you have been affected, and it is permissible. Of course, at the discretion of the court.
Yes, Lordship.
In fact, one of the reasons that's quickly now that I was mentioning about lifestyle, that is why whenever it is a right in rem, it is held to be not arbitrable. For instance, in a patent infringement suit, if the complaint is infringement of patent simpliciter, it is arbitrable because it is between A and B. But if it is regarding the validity of the patent, it is not arbitrable. In a dispute between A and B, private tribunal holds the patent to be valid, then any number of people will be bound by it. That is the reason why those aspects of the matter which deal with the right in rem are broadly held to be not arbitrary.
Lordship, last one question from the participant,
Yes.
Sumti Jain. Her
Yes.
question is, Lordship, what steps should be taken to create awareness among rural areas to choose ADR system rather than moving to courts, as it will also save valuable time of the courts? Her question is, what steps should be taken to create awareness among the rural areas to choose ADR system?
That is more of a, only thing is awareness camps and taking the message across that there is an ADR available by means of probably through the Legal Services Authority or some other, I'm just suggesting of some other entities which have a presence in semi-urban and rural areas, the importance can be stressed and it can be brought to their notice. And they can also be put on guard about before they put pen on paper.
Yes, Lordship. Thank you, Lordship, for patiently answering all the questions raised in this session. Once again, on behalf of our Director of Legal Studies and our Principal, Chennai Dr. Ambedkar Government Law College, Pudupakkam, I humbly thank you, Lordship.
Pleasure. My pleasure. Thank you. My pleasure.
Thank you, Your Lordship. Within a short time, we have learned.
My pleasure. My pleasure.
Within a very short time, we have learned 3 doctrines, 4 principles, close to 20 case laws. Thank you so much, Your Lordship.
Welcome. Welcome.
Now